Lecturecast A for the Legal Rights and Civil Justice module. What is civil justice? Civil justice is most easily defined as being that which criminal justice is not. Civil justice is about issues of social order and economic activity which don't encroach on matters of criminal law. In criminal law, the state takes action against citizens. In civil law, citizens have rights and duties that they may enforce in respect of one another and in respect of the state. Criminal justice is frequently talked about in a variety of ways. For example, criminal justice is regarded as an outcome delivered through a body of law comprised of common law and statutory provisions. Yet despite its origination in many different legal instruments and sources, we acknowledge criminal law as a largely cohesive body of doctrine. Civil law, however, is much more diverse because it contains family law, administrative law, employment law, tort, land law, and so on. In fact, the majority of your study as a legal student concerns civil law rights and duties. Criminal justice is also a system, a dynamic network of organisations, bodies, and activities. For example, the criminal justice system includes the police, the courts, prisons, probation services. Civil justice too is a system. It contains the substantive law of civil rights and duties, as well as the machinery of the state and the judiciary for the resolution of civil justice disputes and grievances. The civil justice system provides the legal architecture for social order and economic stability. In social democratic societies, the power of government must be subject to judicial scrutiny and kept in check, and agreements must be honoured. The civil justice system provides the means for citizens to resolve disputes by exercising legal rights enforced in courts of law. But the value of civil justice is about much more than the legal adjudication of claims. It shapes the expectation of citizens, informing their relations with one another and the state, and it enables an appreciation of what is expected of each of us in our social and economic interactions. It is the civil law that sets out acceptable boundaries of social and economic conduct. It provides a means of redress, and it draws on a system of civil justice to affirm norms and behavioural standards for citizens, corporations, and public bodies. In studies of civil justice traditionally, the issue of access to justice has been predominant. This is because scholars and practitioners recognise that there's little point in having rights if they cannot be enforced. In the UK, this means civil justice is often talked about in relation to legal aid. This is the name given to the bundle of provisions by which the state has enabled people to bring claims. The principle of legal aid, however, has been eroded in recent decades, and provision has been treated by governments as being a financial burden and has been dramatically cut back by Conservative-led governments since 2010. Yet the Supreme Court has recently found it necessary to strongly defend the cause of civil justice as a foundation of civil liberty and democratic freedom. In the case of Unison and the Lord Chancellor in 2017, the Supreme Court reviewed the legality of the introduction of charges for access to the employment tribunals. Since 2012, workers who sought to rely on their statutory rights, for example, if they'd been unfairly dismissed or had been discriminated against for reasons of pregnancy, would need to pay between £390 and £1,200 as a fee for lodging a claim and taking the dispute to a full hearing. In ruling that this was unlawful, Lord Reid asserted that the heart of the concept of the rule of law is for society to be governed by law, because members of Parliament are chosen by citizens and accountable to citizens as they participate in the making of law. Access to a court is integral to the rule of law, and since tribunal fees effectively prevented access to justice, they were unlawful. He went on, and I quote, "Every day in the courts and tribunals of this country, the names of people who brought cases in the past live on as shorthand for the legal rules and principles which their cases established. Their cases form the basis of the advice given to those whose cases are now before the courts, or who need to be advised as to the basis upon which their claim might be fairly settled, or who need to be advised that their claim is hopeless. But the value to society of the right of access to the courts is not confined to cases in which the courts decide questions of general importance. People and businesses need to know, on the one hand, that they will be able to enforce their rights if they have to do so, and on the other, that if they fail to meet their obligation, there is likely to be a remedy against them. It is that knowledge which underpins everyday economic and social relations. That it is so, notwithstanding that judicial enforcement of the law is not usually necessary, and notwithstanding that the resolution of disputes by other methods is often desirable. When Parliament passes laws creating employment rights, for example, it does not do so merely in order to confer benefits on individual employees, but because it is decided that it is in the public interest that those rights should be given effect. It does not envisage that every case of a breach of those rights will result in a claim before an employment tribunal, but the possibility of claims being brought by employees whose rights are infringed must exist if employment relationships are to be based on respect for those rights. It is with a concern for the substance of civil rights that this module has a broader interest in civil justice than that of procedure and access to justice. Our focus is on both legal rights and civil justice, and it combines attention to the content and structure of legal entitlements, as well as the role these rights play in shaping social and economic relationships between citizens and corporations, and between citizens and the state. We have 5 topics to cover in semester 1, and we begin with a consideration of the right to a minimum wage. As a civil justice matter, the right to a minimum wage creates the potential of legal contestation over an economic injury that arises as a breach of a statutory term of contract. As a result of that potential for litigation, the right to a minimum wage crafts the living standards of people in lower waged work, as well as the business viability of employers who are sensitive to labour costs. In the second topic of this module, the right to housing, we consider what it means for a citizen to be recognised by the state as homeless, and the extent to which duties and obligations may fall short of expectations of a social safety net to support people at points in their lives when times are especially hard. The focus of our study in topic 3 is on entitlements to social care. Here, the role of the civil justice system is framed in the context of our ageing population and shrinking public finances. An entitlement to social care revolves around a right to be assessed and informed, yet it doesn't produce a relationship between citizen and state in which the citizen is cared for by the state. Rather, the emphasis is on economic facilitation and enablement to meet shortfalls in care which might otherwise be provided through private relationships with families. In the fourth topic, we look at the right to unemployment benefit, and we explore what citizens must do and the routines in which they must engage in order to qualify for payments at times when they do not have an income from employment. We consider the requirement that citizens without work should work for corporations for free in order to gain work experience as a condition of their entitlement to unemployment benefit. Finally, in topic 5, we consider the legal rights that directly shape civil justice by enabling a right to protest. Our focus is on the democratic principle that all citizens should be free from domination and able to challenge authority. We explore what happens when citizens want to withdraw their labour in protest against their employer and call on a right to strike in the UK. Before Semester 2 gets fully underway, you will choose one of the 5 legal rights from Semester 1 as your specialist interest to carry forward into Semester 2. In your activity seminars, you will be learning about civil justice at the same time as you conduct the research and writing of your coursework for assessment. Your first piece of coursework is a written report of 2,000 words and must be submitted by the 22nd of March. Your second piece of coursework is a report of 1,500 words and is due on the 19th of April. Our 5 topics in Semester 2 are designed to test any and each of the module's legal rights against standards of civil justice. Firstly, we do so through the lens of equality, and we learn how to consider the impact of specific civil rights on social groups who are typically subject to social disadvantage, for example, women, disabled people, or ethnic minorities. Secondly, we consider access to justice and ask whether and how the form or substance of the legal right at issue is sensitive to access to justice limitations. As a third topic in Semester 2, we're holding a student conference in which you will all take part to share your research in progress and hone your presentation skills. The date is the 8th of March, and you should put it in your diary now. The fourth civil justice debate that we explore is the connection between legal fairness and public health, well-being, and democratic participation. The idea we put to the test is that each legal right should support the goal of a healthy, democratic society, and we review the evidence before you conduct your own assessment in relation to your specialist interest. Finally, in Civil Justice Topic 5, we think about the scope of the state in the context of devolution, and we ask whether and how the legal right you have chosen is the responsibility of lawmakers in Westminster or in Wales, and whether the balance is democratically appropriate or legally meaningful. In each of the topics for Semester 2, we hope to be joined by external speakers who will share their expertise in legal rights and civil justice by sharing their knowledge of law in action. So, to recap, legal rights and civil justice is a module which explores the substance of rights in civil law and their impact on the day-to-day social and economic relationships between citizens, between corporations and those they employ, between the state and the citizens it serves, as well as the conceptual relationships between democracy and the rule of law, of which the civil justice system is an integral part.